Thank you for joining us today. I'm here to talk about Patent Office practice and some recent federal court decisions, in particular those with respect to Rokt and Aristocrat. My name is Nathan Madsen. I'm the Supervising Examiner of Patent Examination Section Elect 4, and we deal with data processing and measurements. This is a copy of a presentation I gave to the AIPPI group in July of 2020. So first of all, I'd just like to introduce some of the relevant cases that underpin the current law and practice with respect to computer implemented inventions. These are here for reference. Today, as I said, I'll talk about Commissioner of Patents and Rokt and Aristocrat and the Commissioner of Patents, but also particularly relevant in decisions such as Myriad, RPL, and NRDC as underpinning law for the current processes and practices for dealing with computer implemented inventions. So that's just to give you an idea of the relevant case law. The presentation today will talk about, in summary, some manual changes that were made in early June following some discussions with IPTA and the Law Council. Following a discussion of those manual changes, what I'll do is talk about Rokt and the understanding that the decision is consistent with our approach in determining the patentability of computer implemented inventions following on from RPL. As you will all be aware, Rokt is subject to special leave application to the High Court. I'll then talk about Aristocrat and our application of Aristocrat and how we're looking to modify our guidance in view of that decision. There's some key parts of Aristocrat that I will focus upon. Those are the concept of a device of particular construction, single purpose device of specific character. And that's some stuff that's appearing at paragraph 98 of Aristocrat that, as I said, I'll speak about later in this presentation. And as I said, manual changes are afoot to guide our approach, which essentially address some additional questions that are raised by Aristocrat, expanding upon the principles of RPL. So just going back to the basics of computer implemented invention law and practice, RPL is a piece of law that stands for the principle that mere implementation of an abstract idea or scheme in a well-known machine, a computer or computers, isn't sufficient to confer patentability, or in other words, the mere presence of something you could label artificial or an artificial effect is not sufficient in itself. And this largely follows from Myriad, which talks about the need to determine the substance of the invention in determining patentability. So RPL at 75 critically identifies what you might refer to as touchstones with reference to research affiliates. These are summarized in this Office decision, Aristocrat 2016, at 35 of that decision. And I present a series of those touchstones in this slide. There's more to it than these, but these are some of the key that give you an example of the factors that a decision maker is required to weigh up when considering patentability and the process of determining the substance of the invention. So our first of those is deciding, as to the contribution and whether it is technical in nature. You can ask the question whether the invention solves a technical problem inside a computer or outside a computer. Does the invention result in improvement in the functioning of a computer? That's irrespective of the data that's actually being processed. Is there generic computer implementation, and is there ingenuity in the way in which the computer is utilized? These are identifiers or touchstones that we're all quite comfortable with in being questions that are relevant to ask of a claim and a specification when determining patentable subject matter. So with that as our starting point, I'll move to manual changes that were made on the 2nd of June, following discussions, as I said, with IPTA and the Law Council. And these are consistent with our earlier practice and the earlier Rokt decision of the full federal court. Just to give you a summary of what these changes were, we incorporated part 2.9.2.2 into the manual at 2.9.2.1, just to improve the flow of information and to make it simpler to identify key areas of law that are relevant to the determinations. We removed reference to overseas decisions because the principles of those decisions could be found in recent Australian court decisions. We clarified that the substance of the invention is to be determined by weighing up this variety of factors. So considering all of those different factors that are identified in the earlier slide, for example, from RPL and summarised in that relevant Patent Office decision, the task is reminded to examiners that they're to consider the variety of factors, weighing them up, and making an assessment of what the claim adds to the state of the art at the priority date. We added a new section entitled Role of the State of the Art to clarify the role that art plays in examination of computer implemented inventions and determination of the substance of the invention, pointing out that it's but one of the factors of the RPL type considerations, along with factors such as the consideration of the technical problem and the genericness of computer implementation. We've made it clear to examiners that determining the state of the art beyond the use of common general knowledge is something that they should approach with caution. And this is consistent with the full court decision in Rokt, following on from certain aspects of the Myriad decision, which identify the need to consider the state of the art when understanding where the substance of the invention lies. So what we've said to examiners, and we reiterate, is that in the vast majority of cases, a consideration beyond the common general knowledge is unnecessary and should be avoided. But it does remain clear from those decisions that it is possible to consider information such as expert evidence or particular aspects of prior art. We've also reminded examiners of the important role of construction of the specification in determining patentability. It's clear, particularly from Rokt, that the answers for patentability can generally be found in the drafting of the specification, and that's what their honours appeared to do, largely in the Rokt decision. So we've made that even more clear to examiners in applying their task on a daily basis. So with that in mind, it's useful now to turn to the Rokt decision and understand what the invention is and how their honours came to their particular conclusion for patentable subject matter in that decision. So as a summary, the claimed invention in Rokt was directed to an internet-enabled advertising system that essentially inserts something that was referred to as an engagement offer before an advertisement on the basis of consumer-specific information. So as a user, you're browsing the internet, data is being gathered that depicts the nature of your interaction with that internet web page, so to speak. That data is used to determine something that's known as an engagement journey. And what that constitutes is essentially the insertion of this engagement offer before an actual advertisement. And I'll talk a little bit more about what an engagement offer is on the next slides, but that's the overarching concept that defines the nature of the invention in Rokt. Their honours early in the decision turned quickly to the specification. In discussing that traditional display-based advertising is the process whereby advertisers target their advertisements in association with the type of content that a user is consuming in that moment on their device. This is traditionally a common approach to advertising on the internet. In recent times, display-based advertising has evolved to also evaluate attributes of consumer in order to better target the advertisements displayed to that consumer. So that might be browsing preferences or purchase history or those sorts of things. So this understanding of the nature of contemporaneous marketing in internet systems is something that the specification makes clear is not the nature of the invention, and this is what their honours identified early in the decision. So they note that the following was not part of the invention at 8 of the decision. They say that real-time or contemporaneous targeting of consumers with advertising is not part of the invention, and the contemporaneous evaluation of attributes so that you can target them with a particular ad is also not part of the invention. That's not what that's not where the ingenuity of the application lies. So that's made clear early in the decision. With reference also back to what I identified earlier in the slides with respect to the RPL decision, where those various touchstones and identifiers are laid out, the judges turned to a consideration of the nature of the problem in the Rokt decision. At 9, they discussed the problem solved. The problem solved being that while digital search and display-based advertising are effective in essentially obtaining click-through and conversion of advertisements to improved business outcomes, the actual customer engagement levels, as a matter of absolute data, I guess one could say, is quite low. So often this would result in less than 0.1% of consumers actively following through an advertisement. So there's a desire to increase the click-through, so to speak, of users engaging with internet content. On the right in figure 2 is essentially depicted this process of seeking to improve the click-through and engagement with advertisements. So what happens is a determination of engagement data of a user interfacing with a particular website is gathered. That data is evaluated to create an engagement journey. This includes an engagement offer followed by advertisements. So that engagement offer is presented, and if the user accepts the engagement offer, subsequent advertisements are presented to the consumer or the user. So at this point, making clear what an engagement offer is useful. At 15 of the decision, an engagement offer is identified to be something that might include coupons, discounts, vouchers, surveys, video images, free games, anything like that. It's something that's not an advertisement, and it's something that's inserted before actual advertisements. What their honours labelled this as at 17 was something that you could consider clickbait. So they were inserting information in the form of an engagement offer, preferentially targeted towards the user such that they would be more likely to click through and engage and convert a click through into some sort of, business outcome. So that's a depiction of how their honours have analysed the specification and the invention in view of the principles of RPL to start to come to a conclusion that the invention is not about anything particular in the computer implementation, but instead it's about elements of improved advertising and improved levels of business interaction, which they come to the conclusion that is not patentable subject matter and is business innovation as opposed to technical innovation. So that's a depiction of the Rokt specification. Figure 3 of Rokt is useful to understand the technological architecture essentially that implements the claimed invention of Rokt. What you have is consumers using, in the picture, mobile phones to interact over the internet essentially with published web pages from a publisher and advertisements that are provided by an advertiser. These processes are clearly implemented in the type of architecture depicted in figure 3, which one could say constitutes simply a series of networked computer devices that look somewhat like the internet. So you could see here that the level at which the technology is described can be represented or understood to be what the principles of RPL would determine to be a generic implementation of some kind of program or business process that is applied to this technology. So you can see how that logic is starting to fall out of the Rokt decision. So turning now to some of the specifics of the decision, Rokt doesn't raise any new matters of principle. It's a case that regards the application of those that are already established, including not only RPL, but research affiliates, Encompass and Myriad, and that application is to a particular set of claims. There are, however, as we understand it, some very important points that are confirmed or made clearer in Rokt that are important to discuss as part of this seminar. One thing that's made clear is that the determination of the substance of the invention is essentially part of a construction exercise. It's part of an exercise in understanding what the specification is about. Construction is nothing more than the concept of understanding what you have before you, whether it be construction in the sense of working out what the scope of a claim is and whether it's clear or not, or construction in the sense of performing a fair reading of the specification in light of the relevant prior art to determine whether the claim is to a manner of manufacture. So while one might term the usual concept of construction to be one that determines the scope of a claim and whether it's clear, there is an exercise in determining patentability that requires the decision maker to read the speci as a whole in light of the relevant prior art to make a determination as to what type of invention is actually present and claimed in the application. So that's something that's made clear, and as I said, we've reiterated that to examiners in our recent manual updates. This construction task, for the purpose of determining the substance, can clearly have regard to the evidence as to the state of the art and manufacture at the priority date. So this is a piece of text from Rokt that makes it clear that reference to the common general knowledge at least is clearly possible, and that it's possible to consider information beyond CGK in some cases and potentially expert evidence. In that case, it was unnecessary, and that could be said similarly in the Aristocrat case. So those are some important points that are identified and made clear in Rokt. Some other aspects of Rokt that are also useful is that it makes clear that admissions on the face of the specification are relevant for construction. And that's sort of what I discussed earlier with regard to the generic discussion of computer implementation of the invention at 7 and 8 of the decision, and also the identification of figure 3 of the specification. So the specification is critical to understanding the true nature of the invention by having a look at how the technology is described as implementing the particular method performed and what problems that the specification says that the claimed invention is solving. Rokt reiterates the idea that a mere scheme computer implemented does not become a manner of manufacture unless there's a manner in which that computer is improved in the implementation of that mere scheme. Now, the court noted with reference to the idea, I guess, of section 40, that the level at which the implementation is discussed in a specification, so whether it's discussed generically, whether it's discussed in a specific sense or otherwise, is somewhat of a litmus test for determining whether there's any ingenuity or substance in the manner in which the software operates in conjunction with the hardware, as opposed to the question of the computer is merely used to implement the method. So this aspect of the decision, again, reiterates the idea that the specification tells a very strong part of the story as to whether the claimed invention is patentable or not. And that's, again, consistent with our understanding coming before these decisions. So that's useful to reiterate coming from Rokt. There's some other useful points that are also useful to reiterate from the Rokt decision. Generic software used for its well-known purpose was a reference to computer technology utilized for basic, typical, or well-known functions. So with this in mind, it's important to remember that the fact that software performs a different or new or bespoke function, the fact that software creates a claimed invention that is new and inventive, does not mean that there was a technical advance in the use of computers such that a mere business scheme is patentable because it's computer implemented. The well-known use of computer functions and the fact that it can be used to process data, the fact that a keyboard can be used to enter data, the fact that data can be shared between servers is the well-known function. So that mere implementation of a method using those well-known functions is not enough to transfer something that's a mere business scheme into patentable subject matter. And that's, again, a re-emphasis of the principles that were already present in decisions such as RPL and research affiliates. And this can be summarized, I guess, by the idea that there's the well-established principle that merely plugging an unpatentable scheme into a computer does not make it a manner of manufacture. And there was reference made to the colloquial understanding of the case of the emperor's new clothes, I guess. So that's what Rokt presents us with. Again, I'll reiterate some of the important points that we see being identified in the Rokt decision. The question of manner of manufacture is one that involves a construction of the specification and a characterizing of the invention as a matter of substance. And this is done with an understanding of the state of the art. This is generally involving an understanding of the state of the art to the degree of common general knowledge, but it may include more information if the case warrants or requires the consideration of further information. And this is done using the touchstones identified in RPL. And there's relevant parts of our manual. One of those is 2.9.2.7 that I'd refer you to see more information about that process. We've also, as I said, communicated to examiners that it's important to note that the court didn't simply remove features as part of the state of the art and ask what was left over. So the task of identifying the substance is not simply ignoring or removing elements that are well known. Determining of the substance of the invention is not simply a matter of elimination of these features. Identification of the contribution to the art and what the invention brings as a matter of objective ingenuity is an element of determining the substance of the invention and patentability consistent with 2.9.2.7, but it's not the only element. There's other questions to ask of the claimed invention. There's other indicators that are also relevant to consider, and this is also something that we've reminded examiners about, and as I said, appeared in the manual amendments that I spoke about earlier. So that's Rokt. Aristocrat now is one that also warrants careful consideration. In Aristocrat, the claimed invention was to an electronic gaming machine. That electronic gaming machine had a series of physical features. It had a display, a random number generator, a game controller, buttons, a credit input mechanism. It had meters that showed the value of credit input and that remaining in the machine. And this was configured to execute a game involving what were configurable and non-configurable symbols, which created trigger events and free games. It turns out, and I'll discuss a little bit further on that, the nature of the games or the game played in the Aristocrat decision per se was not determinative of the outcome. And in that sense, I'll focus on the way His Honour in Aristocrat proceeded to analyse that specification and come to his conclusion. So with that in mind, at the priority date at 30 of Aristocrat, it's discussed that EGMs typically consisted of those physical features and that they were distinguished from each other largely by the way that those features utilize the physical hardware and components to provide different products that would engage and entertain users in different ways. That's at 31 of the decision. One could interpret that to say largely these machines were distinguished from each other by the particular games that were played on them. At 32 to 45 of the decision, there's a discussion of the evolution of gaming machine technology, which starts at the concept of old mechanical spinning reel machines and ends with a discussion of regulatory standards that are applied to EGMs and appear to apply limitations to the manner in which they're to be constructed. One can understand further the invention of Aristocrat by having a look at a couple of figures of that specification. Figure 2, I guess, is a more important one than the one that shows a bit of a display screen there. Figure 2, as I'm sure we'd all be comfortable being familiar with, is the cabinet box structure type that we see the gaming machines implemented on. So you've got this large box device with a display, a physical display and a virtual display, one might say. We've got buttons, we've got a coin input slot at 24A. We've got various physical features there giving you a form of a cabinet that we commonly see as a gaming machine cabinet. So that's an important aspect of understanding the nature of the invention. The other figures that I discuss in 67 of Aristocrat essentially are just a depiction of the game that's played on the particular device in that Aristocrat specification. It involves configurable symbols and non-configurable symbols, some triggers and bonus games. As I said, the game itself is not determinative of the outcome of the Aristocrat decision, it appears, so I won't discuss it any further. It's just useful to give you an understanding of what's going on with the invention in that specification. So moving on to the decision itself, there's a number of principles that are identified in Aristocrat that consistent with Rokt and reiterate some of those points I made earlier with respect to the Rokt decision. Furthermore, included in Aristocrat is the formulation of anterior and posterior questions, which is something compared to earlier decisions that is now manifested clearly at 91 of Aristocrat. But with that in mind, reiterating again some of the principles of Rokt, the full court made clear that the role of evidence in considering the specification, understanding manner and manufacture is limited, and this is something that was reiterated in Aristocrat. Expert evidence generally is something that is not necessary, or its role, as it's said there, is limited in understanding the nature of the invention. The specification itself generally answers those questions. So 27 of Aristocrat reiterates those points that were made in Rokt. Aristocrat also reiterates the idea that the question of construction remains with the court. The task of construing the specification involves arriving at a characterization of the invention in order to determine whether it's in substance or manner of manufacture. So those are ideas that, again, are consistent with Rokt and an earlier case law, and is a reiteration of those important points that are required of examiners and decision makers when determining patentability. The decision also notes at 86, again consistent with those earlier decisions, that the commencement of any analysis of manner of manufacture requires a determination of whether the claims, as read in light of the spec as a whole and the relevant prior art, which in the present case of Aristocrat included the common general knowledge, are for a manner of manufacture. So again, at 86 of Aristocrat, we see a clear articulation of those principles that are emerging from RPL and research affiliates. At 91, there's now the idea that reference is made to a number of decisions, but particularly RPL Central at 96, where Justice Burley formulates a two-stage analysis at 91 of his decision. This two-stage analysis being a first question of asking, is the claimed invention for a mere scheme or business method? And if one is to answer this yes, then one is to analyze that claimed invention in the context of seeking whether the invention lies in the computerization of the method. So our understanding of this two-stage approach is that Justice Burley is asking, first of all, whether you could define it or determine that the claim is directed to a mere scheme or business method. If it's not, then you need not go any further. You need not consider the principles of RPL and the other relevant cases. And that's essentially what it appears that the process of decision making has occurred in this case. So how does one approach this two-stage analysis? Our advice to examiners is, as I'll show you on the next slide, is largely with reference to paragraph 98 of the Aristocrat decision, which I'll talk about, as I said, on this slide. But before I get to 98, I'll discuss a little bit more of the text that leads to the conclusion of patentable subject matter. At 96 of Aristocrat, there is another discussion again of the physical device and the fact that it has display reels, a credit input mechanism, meters. It has a gameplay mechanism with buttons. It has a game controller. And these essentially at 96 come together in some way to play a particular game, that being that game I showed you earlier on those figures. Following this paragraph, it's noted that the expert evidence reveals that electronic gaming machines are subject to regulatory supervision and this imposes requirements on the construction of cabinets. What, that, and whether those regulatory requirements impose further limitations on the claimed invention in Aristocrat is not entirely clear. But what paragraph 98 following that does is to give us an idea of how to make a determination of patentability in the positive sense for these types of computer implemented inventions following this decision of Aristocrat. So His Honour at 98 says that the invention may be characterised as a machine of particular construction which implements a gaming function. It's built to allow people to play games on it, and that is its only purpose. So it's a machine of particular construction, and it can only do one thing. It can only play games. That appears to be the logic that's following from that discussion, starting at 91 and going through 96, 97 to 98. That's its only purpose. Physical and virtual features of the display, reels, credit input mechanisms, and gameplay mechanism and the controller combine to produce the invention. It's a device of specific character. So 98 appears to us to be particularly relevant in making that determination of that two-stage analysis that I mentioned was identified at 91 of the decision. And this is where we're guiding examiners to make their consideration clear in determining whether what they have before them is a machine of particular construction. It's a single purpose device. It's something that could be characterized as a device of specific character. So this is particularly relevant to the decision making, and as I said, we're working on manual modifications to assist with this. To complete sort of the chronological travel through the Aristocrat decision, I'll point out just briefly that at 102, analogy was again made with old-fashioned gaming machines that were mechanical spinning reels, and reference was also made to earlier decisions which were pre-RPL Central where electronic gaming machines were found patentable. So that presents the Aristocrat decision and the logic that Justice Burley comes to making that call on patentability. As I said, we'll seek to make modifications to our approach in the manual. We'll be taking care in our approach in applying Aristocrat with regard in particular to one of the key findings at 98 and how this relates to a determination of the substance of the invention. With that in mind, there's no doubt that generically implemented methods will continue to face difficulty in the CII space when they're related to business improvements in accordance with RPL, Rokt, and Encompass. These are full court decisions that present a clear picture of the law and do still stand for the concept that mere implementation of an otherwise unpatentable scheme is not patentable. As I mentioned, the device of particular construction, single purpose device concept is particularly relevant to our consideration. Now, electronic gaming machines directed to a cabinet and all of their constituent integers in the manner described in the Aristocrat decision is clearly something that is considered to be patentable. One could say that there's potentially other single purpose devices that would fall under this characterization. We're not going to seek to identify these as such. They might be things along the lines, for example, of ATM machines, vending machines, those sorts of things might fall under that category, but we won't be seeking to identify what might also fall under the similar realm of electronic gaming machines. We'll be modifying our guidance in particular areas of the manual, 2.9.2.1, 0.7 and 0.9. And there's a couple of office decisions also with respect to Aristocrat applications that are relevant to this gaming machine technology. On inspection of those, we're comfortable that this decision doesn't change those outcomes. Those cases in Aristocrat 16 and 17, the claimed inventions were not directed to specifically constructed devices as EGMs in the manner of the Aristocrat federal court decision, so they remain untouched. As you would be aware, the Commissioner has filed an application for special leave back in July, and we're awaiting that hearing in the coming future. So thank you for your time. My details, and I can be contacted at the office at the email address found therein. I hope you've found this presentation useful, and all the best. Thank you.